Let's get you ready for the real estate exam with a review of the key elements that make a real estate contract valid. We'll cover essentials like offer and acceptance, consideration, legality, and the capacity of the parties. And keep an eye on the bottom corner. There's something there that could give your prep a serious boost. Let's get started.
Let's begin with a general review of real estate contracts. Starting with contract fundamentals. Essential elements of a valid contract: offer, acceptance, consideration, capacity, legality. Which of the following is not an essential element required for a valid real estate contract? Is it A, mutual consent, B, legality, C, witnesses, or D, consideration? The answer is C. Why this question may seem a bit tricky. The options include terms that sound legally significant. However, mutual consent, legality, and consideration are essential, while witnesses are not required for validity. In a real estate contract, what does capacity refer to? Is it A, the financial ability to purchase property, B, the legal ability to enter into a contract, C, the physical space available in a property, or D, the capacity to negotiate terms? The answer is B, the legal ability to enter into a contract. Why this question may seem a bit tricky. The term capacity could be confused with physical or financial capacity. Here, it refers to the legal ability to enter into a contract.
Have you noticed the code in the bottom corner? Next time you're stumped, take that code to birdsy.ai for immediate help and a free study session with Birdsy, your personal AI study partner. Plus, you'll get access to hundreds of additional questions, helping you move closer to passing your exam with confidence. The next time you're feeling unsure or stuck, give it a try.
Which of the following scenarios would result in a contract lacking legality? Is it A, a contract to sell stolen property, B, a contract signed by a minor, C, a contract missing a signature, or D, a contract with a typo in the address? The answer is A, a contract to sell stolen property. Why this question may seem a bit tricky. The scenarios include legal terms, but only one involves an illegal act, which invalidates the contract. Which element of a contract is concerned with the exchange of value between parties? Is it A, acceptance, B, offer, C, legality, or D, consideration? The answer is D, consideration. Why this question may seem a bit tricky. The options include related terms, but only consideration specifically involves the exchange of value, a key contract element. Which of the following statements about acceptance in a real estate contract is false? Is it A, acceptance must mirror the offer exactly, B, acceptance can be communicated verbally or in writing, C, acceptance must be communicated to the offeror, or D, acceptance can be implied by silence? The answer is D, acceptance can be implied by silence. Why this question may seem a bit tricky. The statements are all plausible, but only one is incorrect regarding acceptance, which must be unequivocal. Which of the following would not fulfill the requirement of legality in a real estate contract? Is it A, a contract to sell a house, B, a lease agreement for an apartment, C, a contract to build a new office, or D, a contract to sell stolen property? The answer is D, a contract to sell stolen property. Why this question may seem a bit tricky. The use of not can easily be overlooked. A contract for illegal purposes like selling stolen property lacks legality and is unenforceable. Types of real estate contracts: listing agreements, purchase agreements, option contracts, leases. Which of the following is not a type of listing agreement commonly used in real estate transactions? Is it A, exclusive right to sell, B, open listing, C, net listing, or D, exclusive agency? The answer is C, Net listing. Why this question may seem a bit tricky. The options include terms that sound like legitimate agreements. The net listing is a less common and often discouraged type of agreement due to ethical concerns. In a purchase agreement, which party typically holds the earnest money deposit until closing? Is it A, buyer, B, escrow agent, C, seller, or D, real estate agent? The answer is B, escrow agent. Why this question may seem a bit tricky. The term earnest money might lead one to assume it is directly handled by the buyer or seller, but it is usually held by a neutral party. Which of the following is not typically included in a lease agreement? Is it A, closing date, B, rent amount, C, security deposit, or D, lease term? The answer is A, closing date. Why this question may seem a bit tricky. Lease agreements and purchase agreements both involve property terms, but they differ in purpose. A closing date is specific to purchase agreements, not leases. What is the primary difference between an option contract and a purchase agreement? Is it A, option contract is binding for both parties? B, purchase agreement allows buyer to opt out anytime? C, option contract includes a financing contingency? Or D, option contract gives buyer the right, not obligation, to buy? The answer is D, option contract gives buyer the right, not obligation, to buy. Why this question may seem a bit tricky. Both contracts seem similar as they involve property transactions. However, an option contract grants a right, not an obligation, to purchase.
If you're finding this helpful, please take a minute to like this video and subscribe to our channel for more practice exams, useful tips, and complimentary study sessions with Birdsy.
Which type of real estate contract typically involves a right of first refusal clause? Is it A, purchase agreement, B, listing agreement, C, lease agreement, or D, option contract? The answer is C, lease agreement. Why this question may seem a bit tricky. The term right of first refusal can be confused with various contract types, but it is most commonly associated with lease agreements. Which of the following statements about option contracts in real estate is incorrect? Is it A, option contracts grant the buyer the right to buy a property? B, option contracts require a fee to be paid by the buyer? C, option contracts obligate the buyer to purchase the property? Or D, option contracts can be exercised within a specific time frame? The answer is C, option contracts obligate the buyer to purchase the property. Why this question may seem a bit tricky. The phrasing requires identifying an incorrect statement, which can be confusing. Option contracts give the buyer the right, not obligation, to purchase. They do not bind the buyer to purchase, contrary to purchase agreements. In a listing agreement, who is typically responsible for marketing the property? Is it A, the listing agent, B, the seller, C, the buyer, or D, the home inspector? The answer is A, the listing agent. Why this question may seem a bit tricky. The wording might suggest shared responsibilities. Typically, the listing agent is responsible for marketing the property as outlined in the listing agreement rather than the seller or buyer. Valid, voidable, and unenforceable contracts. Which of the following statements about a void contract is not true? Is it A, a void contract is unenforceable by either party? B, a void contract is treated as though it never existed? C, a void contract can be ratified by mutual consent? Or D, a void contract lacks essential elements of a contract? The answer is C, a void contract can be ratified by mutual consent. Why this question may seem a bit tricky. The use of not requires careful reading. A void contract is one that lacks legal effect from the beginning. It cannot be ratified as it never existed legally. A real estate contract that lacks mutual consent due to one party being intoxicated at the time of signing is it A, valid, B, void, C, voidable, or D, unenforceable? The answer is C, voidable. Why this question may seem a bit tricky. The scenario might suggest a void contract, but intoxication makes it voidable. A voidable contract can be ratified or rescinded by the affected party, unlike void contracts, which are invalid from the start. Which of the following contracts is unenforceable due to lack of consideration? Is it A, a promise to give a gift without any return, B, a signed agreement with mutual promises, C, a contract with a future promise of payment, or D, a contract with a nominal exchange of $1? The answer is A, a promise to give a gift without any return. Why this question may seem a bit tricky. Contracts may appear valid, but lack of consideration makes them unenforceable. Consideration is a crucial element, and without it, a contract cannot be enforced. What makes a contract voidable rather than void? Is it A, lacking legal capacity from the start, B, missing an essential contract element, C, having an illegal purpose, or D, involving misrepresentation by one party? The answer is D, involving misrepresentation by one party. Why this question may seem a bit tricky. The distinction between void and voidable can be subtle. A voidable contract is valid unless a party chooses to void it, often due to issues like misrepresentation. Which situation results in an unenforceable contract? Is it A, a contract signed by a minor, B, a contract with mutual consent, C, a contract violating the statute of frauds, or D, a contract with a legal purpose? The answer is C, a contract violating the statute of frauds. Why this question may seem a bit tricky. Contracts can be unenforceable for various reasons. A contract that violates the statute of frauds is unenforceable because it lacks the necessary written form. A contract signed under duress is considered. Is it A, valid, B, void, C, voidable, or D, unenforceable? The answer is C, voidable. Why this question may seem a bit tricky. The term duress might lead one to think of invalidity. A contract signed under duress is voidable, not void, because the affected party can choose to enforce or void it. Which of the following would render a real estate contract void? Is it A, a minor signing the contract, B, a mistake in the property description, C, failure to notarize the contract, or D, a contract for an illegal purpose? The answer is D, a contract for an illegal purpose. Why this question may seem a bit tricky. The use of void could be confused with voidable. A contract for illegal purposes is void because it lacks a lawful objective, which is essential for validity. Contract performance and discharge. Breach of contract and legal remedies, damages, specific performance, rescission. Which of the following is not a legal remedy for breach of a real estate contract? Is it A, damages, B, specific performance, C, arbitration, or D, rescission? The answer is C, arbitration. Why this question may seem a bit tricky. The options include terms that sound like legal remedies, but aren't. Remedies in real estate typically include damages, specific performance, and rescission, but not arbitration, which is a dispute resolution process. In a real estate contract breach, which remedy involves the court ordering the completion of the transaction? Is it A, specific performance, B, compensatory damages, C, punitive damages, or D, liquidated damages? The answer is A, specific performance. Why this question may seem a bit tricky. The options use similar legal terminology. Specific performance is the remedy where the court mandates the breaching party to complete the contractual obligations, typically used in unique property transactions. Which scenario would most likely lead to rescission as a remedy in a real estate contract breach? Is it A, a minor delay in closing due to financing issues? B, seller's refusal to make minor repairs? C, buyer's inability to secure a loan? Or D, fraudulent misrepresentation of property boundaries? The answer is D, fraudulent misrepresentation of property boundaries. Why this question may seem a bit tricky. The scenarios all involve breaches, but rescission is appropriate when the contract is invalid or voidable, such as due to fraud or misrepresentation. Which of the following statements about damages in real estate contract breaches is false? Is it A, compensatory damages aim to cover actual losses? B, punitive damages are commonly awarded in contract breaches? C, liquidated damages are pre-agreed amounts specified in the contract? Or D, nominal damages recognize a breach occurred without substantial loss? The answer is B, punitive damages are commonly awarded in contract breaches. Why this question may seem a bit tricky. The statements are similar, but the false one claims punitive damages are standard, which is incorrect. Punitive damages are rare and not typically awarded in contract breaches. If a buyer breaches a real estate contract, which remedy would allow the seller to retain the earnest money deposit? Is it A, specific performance? B, compensatory damages? C, rescission? Or D, liquidated damages? The answer is D, liquidated damages. Why this question may seem a bit tricky. The options include remedies that sound similar. Liquidated damages allow the seller to keep the earnest money as compensation for the breach.
Stuck on a question? Just think of the Birdsy link in the description as your friendly neighborhood superhero, swooping in to save the day with answers. Feel free to explore it now and return to continue. Simply hit pause, and we'll be waiting when you get back.
Time is of the essence, and other common clauses. In a real estate contract, which of the following best describes the time is of the essence clause? Is it A, deadlines are flexible and can be adjusted by mutual agreement? B, deadlines are suggested and can be ignored without consequence? C, deadlines are critical and must be adhered to exactly? Or D, deadlines are important but can be extended with a valid reason? The answer is C. Deadlines are critical and must be adhered to exactly. Why this question may seem a bit tricky. The phrase, time is of the essence, sounds straightforward, but its implications can be misunderstood. This clause means that deadlines are critical and must be met exactly. Missing a deadline can result in a breach of contract. Which statement about the time is of the essence clause is not true? Is it A, it allows for missed deadlines without consequences? B, it emphasizes the importance of meeting contractual deadlines? C, failure to meet a deadline can result in a breach of contract? Or D, it is a common clause in real estate contracts? The answer is A, it allows for missed deadlines without consequences. Why this question may seem a bit tricky. The negative wording can lead to confusion. The clause does not allow for missed deadlines without consequences, contrary to what some might think. Which of the following scenarios best illustrates a breach due to a time is of the essence clause? Is it A, the buyer requests an extension for closing due to unforeseen circumstances? B, the seller fails to deliver the deed by the specified closing date? C, the buyer pays the deposit a day early? Or D, the seller and buyer agree to a new closing date? The answer is B, the seller fails to deliver the deed by the specified closing date. Why this question may seem a bit tricky. The scenarios presented might seem similar, but only one directly involves a breach due to the clause. The clause enforces strict adherence to agreed deadlines. How does the time is of the essence clause affect the enforceability of a real estate contract? Is it A, It makes the contract unenforceable if any deadline is missed. B. It allows for flexible interpretation of deadlines. C. It has no impact on the contract's enforceability. Or D. It requires strict adherence to all specified deadlines. The answer is D. It requires strict adherence to all specified deadlines. Why this question may seem a bit tricky. The clause's impact on enforceability can be misunderstood. It ensures deadlines are strictly enforced, making the contract more rigid in terms of time obligations. Which of the following is a common misconception about the time is of the essence clause? Is it A. It is included to emphasize deadline importance. B. It converts suggested deadlines into mandatory ones. C. It allows for negotiation of deadlines after the contract is signed. Or D. It can lead to a breach of contract if deadlines are missed. The answer is C. It allows for negotiation of deadlines after the contract is signed. Why this question may seem a bit tricky. Misconceptions arise due to misunderstanding the clause's strict nature. Many believe it allows for some leeway, but it actually enforces strict compliance with deadlines. Assignment and novation. Which of the following statements about assignment of a real estate contract is not true? Is it A. Assignment transfers all rights and obligations to the assignee. B. An assignment does not relieve the assigner of liability unless the contract states otherwise. C. The assignee must perform the contract terms as agreed upon by the original parties. Or D. Consent from the other party may be required for an assignment. The answer is B. An assignment does not relieve the assigner of liability unless the contract states otherwise. Why this question may seem a bit tricky. The question uses negative wording, asking for the statement that is not true. Assignment transfers rights but not obligations unless the contract specifies otherwise. In a novation, what is the primary difference compared to an assignment? Is it A. Both novation and assignment involve a change of parties. B. Novation and assignment both require the consent of all parties. C. In novation, the original contract remains intact. Or D. Novation substitutes a new party and releases the original party from obligations. The answer is D. Novation substitutes a new party and releases the original party from obligations. Why this question may seem a bit tricky, the options are similarly worded, which may confuse test takers. A novation replaces an original party, while an assignment does not. Which scenario best describes a novation in real estate contracts? Is it A. A buyer and seller agree to replace the buyer with a new party who assumes all obligations? B. A seller assigns their rights to receive payments to another party. C. A buyer delegates their duty to inspect the property to a third party. Or D. A landlord allows a tenant to sublease the apartment to another tenant. The answer is A. A buyer and seller agree to replace the buyer with a new party who assumes all obligations. Why this question may seem a bit tricky. The scenarios include unnecessary details that might distract from the key concept of novation. Novation involves replacing an original party with a new party. Which of the following is always required for a novation to occur? Is it A. The original contract must be terminated. B. The original party must remain liable. C. Consent of all parties involved is required. Or D. A new contract must be drafted. The answer is C. Consent of all parties involved is required. Why this question may seem a bit tricky. The use of always can mislead, as not all options are universally required. Consent from all parties is essential for novation. What is the main reason an assignment may be invalidated in a real estate contract? Is it A. The assigner did not notify the assignee? B. The assignment violates a clause in the original contract? C. The assignee is not financially capable? Or D. The assignment was not notarized? The answer is B. The assignment violates a clause in the original contract. Why this question may seem a bit tricky. The question includes similar-sounding options that may confuse test takers. An assignment can be invalidated if it violates contract terms. Contract law and interpretation. Statute of frauds and writing requirements. Which of the following contracts must be in writing to be enforceable under the statute of frauds? Is it A, a lease for 6 months, B, a verbal agreement to build a fence, C, an agreement to sell a parcel of land, or D, a handshake deal to rent an apartment for 11 months? The answer is C, an agreement to sell a parcel of land. Why this question may seem a bit tricky. The statute of frauds requires certain contracts to be in writing, but not all real estate-related contracts. Leases for less than a year may not require writing. Contracts for the sale of land must be in writing to be enforceable. In which of the following situations does the statute of frauds not require a written contract? Is it A, a lease agreement for 9 months, B, a contract for the sale of a commercial building, C, an easement agreement for 5 years, or D, a purchase option on a parcel of land? The answer is A, a lease agreement for 9 months. Why this question may seem a bit tricky. It's easy to assume all real estate transactions require written contracts. However, leases for less than a year are typically exempt from the statute of frauds writing requirement. Which of the following is not a requirement for a real estate contract to satisfy the statute of frauds? Is it A, the contract must be in writing, B, the contract must be witnessed by 2 people, C, the contract must be signed by the party to be charged, or D, the contract must include essential terms? The answer is B, the contract must be witnessed by 2 people. Why this question may seem a bit tricky. The statute of frauds focuses on the necessity of a written form, not the presence of witnesses. A written agreement signed by the party to be charged is essential. A verbal agreement to sell a house is made between 2 parties. Under the statute of frauds, what is the status of this agreement? Is it A, enforceable because both parties agreed, B, enforceable if witnessed by a third party, C, enforceable if partial payment is made, or D, unenforceable because it is not in writing? The answer is D, unenforceable because it is not in writing. Why this question may seem a bit tricky. Verbal agreements can be binding in some contexts, but not for real estate sales. The statute of frauds requires such agreements to be in writing to be enforceable. Which of the following statements about the statute of frauds is false? Is it A, it requires certain contracts to be in writing, B, it applies to contracts for the sale of land, C, it applies to all verbal agreements, or D, it requires the signature of the party to be charged? The answer is C, it applies to all verbal agreements. Why this question may seem a bit tricky. The statute of frauds is often misunderstood. It requires written contracts for certain agreements, like real estate sales, but does not apply to all verbal agreements.
If you're finding this helpful, please take a minute to like this video and subscribe to our channel for more practice exams, useful tips, and complimentary study sessions with Birdsy.
Parol evidence rule and contract interpretation. Which of the following is not typically allowed under the Parol evidence rule in real estate contracts? Is it A, clarifying ambiguous contract terms, B, showing subsequent modifications to the contract, C, introducing prior agreements to alter written terms, or D, proving that the contract was void or voidable? The answer is C, introducing prior agreements to alter written terms. Why this question may seem a bit tricky. The Parol evidence rule can be confusing due to its exceptions. The rule generally excludes prior agreements, but allows clarification of ambiguous terms. Here, clarification is allowed, but prior agreements typically aren't. In which scenario would the Parol evidence rule most likely prevent additional evidence from being considered? Is it A, a fully integrated written contract with no ambiguity? B, a contract with an oral agreement made after signing? C, a partially written and partially oral contract? Or D, a written contract with a typographical error? The answer is A, a fully integrated written contract with no ambiguity. Why this question may seem a bit tricky. The rule's application can be nuanced, especially when considering fully integrated contracts. Here, the fully integrated nature means no external evidence is allowed. Which statement about the Parol evidence rule is false? Is it A, it applies to written contracts that are intended to be complete? B, it always excludes evidence of fraud or duress? C, it can exclude evidence of prior negotiations? Or D, it is a rule of substantive law, not procedural law? The answer is B, it always excludes evidence of fraud or duress. Why this question may seem a bit tricky. The challenge lies in understanding the exceptions to the rule. The rule doesn't always exclude external evidence. It allows it under specific circumstances, like fraud. Which of the following scenarios would allow the use of Parol evidence in a real estate contract dispute? Is it A, to add terms not included in a fully integrated contract? B, to explain a clear and unambiguous term? C, to contradict a written agreement with prior oral agreements? Or D, to prove fraud in the inducement of the contract? The answer is D, to prove fraud in the inducement of the contract. Why this question may seem a bit tricky. The rule's exceptions can be subtle. Fraud is a clear exception, allowing Parol evidence, whereas other scenarios may not permit it. Under what condition might Parol evidence be admissible to interpret a real estate contract? Is it A, to modify the contract terms based on a prior oral agreement? B, to add new terms to a fully integrated contract? C, to clarify ambiguous language within the contract? Or D, to introduce evidence of a party's intent contrary to the written terms? The answer is C, to clarify ambiguous language within the contract. Why this question may seem a bit tricky. The rule's exceptions can be easily overlooked. Ambiguity in a contract is a key exception that allows for Parol evidence. Contingencies and addenda. Which of the following is not typically included as a contingency in a real estate contract? Is it A, financing contingency? B, inspection contingency? C, pet approval contingency? Or D, appraisal contingency? The answer is C, pet approval contingency. Why this question may seem a bit tricky. The question uses a negative format, asking for what is not included, which can easily confuse test takers. Financing, inspection, and appraisal contingencies are common, but a pet approval contingency is not standard. When a buyer adds an addendum to a contract, what is the primary purpose? Is it A, to modify the original terms of the contract? B, to clarify existing terms without changes? C, to summarize the contract for easier understanding? Or D, to list potential issues with the property? The answer is A, to modify the original terms of the contract. Why this question may seem a bit tricky. The options sound similar, but an addendum specifically modifies the original contract terms, not just clarifying or summarizing them. Which statement about contingencies in a real estate contract is false? Is it A, contingencies must be met for the contract to be binding? B, contingencies can protect both buyers and sellers? C, common contingencies include financing and inspection? Or D, contingencies are optional and rarely used? The answer is D, contingencies are optional and rarely used. Why this question may seem a bit tricky. The question asks for a false statement, which can mislead if not read carefully. Contingencies are indeed conditions that must be met, not optional clauses. What happens if a contingency is not fulfilled in a real estate contract? Is it A, the contract automatically extends until it is fulfilled? B, the contract may be terminated by the affected party? C, the party failing to fulfill the contingency pays a penalty? Or D, the contract terms are renegotiated to remove the contingency? The answer is B, the contract may be terminated by the affected party. Why this question may seem a bit tricky. The options are worded to sound similar. The correct answer involves contract termination, not automatic extension or penalty. Which of the following best describes an addendum in a real estate contract? Is it A, a summary of the contract terms for clarity? B, an appendix with additional property details? C, an addition or change to the existing contract? Or D, a list of potential contingencies to consider? The answer is C, an addition or change to the existing contract. Why this question may seem a bit tricky. Similar sounding options can confuse test takers. An addendum is an addition or change to a contract, not just a summary or appendix.
Thanks for joining us today. If you found this video helpful, subscribe to our channel for more practice exams, tips, and tricks. And don't forget to visit Birdsy.ai for complimentary study sessions with Birdsy, your AI-powered study partner.